Okay, good morning. This is Judge Lopez. Today is December 1st. I'm going to call the 9 o'clock case, Core Scientific here on a hearing, case number 22-90341. The line is completely unmuted. Oh, right. There's a little over 40 people. I'm going to enable the voice feature. If you wish to make an appearance, why don't you hit 5-star.
Conference muted.
Well, I take appearances in the courtroom, and then we will see where we are.
Good morning, Your Honor. Ashley Harper and Brandon Bell on behalf of Sphere 3D Corp., and we're joined on the phone by Greg Wolf, who will be taking the lead from our side today.
Okay, thank you.
Good morning, Your Honor. Jennifer Hardy of Wilkie Farr on behalf of the Official Committee of Unsecured Creditors.
Okay, good morning. I'm just going to go in the order in which I see them here. There's a 212 number.
Your Honor, it's Ted Sekarides from Waugatcho. I've not seen the courtroom on my go-to meeting.
I don't see you as well, Mr. Sekarides, but if I can hear you, we're in good shape.
I apologize. I am dressed appropriately.
No worries. There's a 917 number.
I believe that will be me, Judge Greg Wolf.
Oh,
First Sphere.
You got it. Good morning.
Good morning.
Anyone else, please, if you wish to make an appearance, just hit 5-star. Okay, who do I turn this over to?
I guess that would be me. It's Mr. Sekarides. And again, I apologize, Your Honor. I don't know what's happened here, but if it's okay with you, I'll proceed without the video.
Not a problem at all.
Okay, well, first of all, thank you for hearing us on an emergency basis. We appreciate that the court has a lot going on, and making the time for us is very much appreciated. The motion that we filed is one to vacate the scheduling order in a contested matter between the debtors and a company called Sphere 3D that has been pending for a few months, and consolidating that with an adversary proceeding that the debtors filed, I guess, about a week or so ago. And sort of a corollary to that would be to have either today or at some other point in the near future some kind of scheduling to allow the party defendants to file an answer or to move, as some have indicated that they're intending to do so, with respect to the complaint. By way of some background, which I'm sure you've had some limited opportunity to review the papers, but this is a matter that arises out of a master services agreement that the debtors signed with Griffin, and it's Griffin Digital Mining. Sphere is not a signatory to any of those contracts. The agreement ultimately had two, what they call orders. First one was like a test order to see if miners that were going to be supplied by Griffin could actually work and that they were appropriate. And there was about 100 of those. And then the other order is really the meat of what's at issue here, was for 70,000 miners to be delivered by Griffin and hosted by the debtors. Now, it's our view that Griffin breached that when they either didn't have them or some of these miners didn't even really exist, but they never delivered the miners, and our view was that that was a breach and no further obligations were owed. At the time, there were still roughly 639, don't hold me to the exact number, but it's around there, of miners that Griffin supplied that were at court. Those miners are still there, and as an accommodation given the party's history, the debtors have been hosting those miners and at Griffin's direction sending wherever the Bitcoin is supposed to go. And the reason I raise that is because it ties into something that's important both for the adversary proceeding, but also as relates to some immediate issues that the parties have to deal with. That immediate issue is that our view is that those contracts are not executory. It's not part of our business plan to continue hosting these miners. We have no intention to continue hosting these miners. And in fact, I think attached to either the complaint or it was on motion, was a letter that the debtors sent to Griffin, again, as the only party that we feel we have a contract with, that effective December 18th, we are decommissioning and turning off those miners, and they should come pick them up. And I understand that folks from Griffin have been in touch with the debtors about that, and I want to stress on this call that communications relating to that should flow through counsel at this point. This is something that the debtors feel very strongly about. The only entity we have a contract with is Griffin, and we don't want any miscommunications that can result in any unwarranted conduct. So since Sphere has made some statements that they had asked for these miners apparently in the past, and we refused to return them. And just on that note, we have no record of that ever happening, but it's moot at this point. Sphere should have no issue with what we're saying either, but this is very important. December 18th, those miners will be turned off. If Griffin and Sphere have issues as to whose they are between them, they should work it out. That's not our issue, but the two of them need to get together. We're going to deal with Griffin, and we're going to get the miners back to them. And the reason why that's important for the adversary proceeding is because Griffin and Sphere may have different views about whether or not what I just said is right in terms of whether these are executory contracts or not. So that's one of the claims that we have. We think that they're not, but regardless, even if they are, we're rejecting them. And if I have to make that motion like right now, then I'm doing it. It's not part of our business plan, business judgment to get rid of these. Plus, they say they want them back anyway. But if they then were to prevail that it was an executory contract and then file claims for rejection damages, those are quintessential 365 bankruptcy issues that would have to be heard in this court. And the response from the debtor to that will be the same facts and circumstances that are at issue in the Sphere contested matter. This all comes down to what happened after these contracts were signed. Does Sphere have rights? Did Griffin breach? Did the debtors breach? What happened? All of those issues permeate the adversary proceeding, issues relating to the contract claim in the rejection context, or we say not executory to begin with, and in the Sphere contested matter. And for that reason alone, frankly, Your Honor, the adversary proceeding and the Sphere contested matter should be consolidated. I know Sphere has different views. I know Griffin wants to file a motion to arbitrate. We think that would fail, but okay, I mean, they're entitled to file the motion, and we'll deal with it in the appropriate briefing. But what we don't want to have happen is we have a fight with Sphere. Griffin, who signed the contracts, is not there. Either Sphere loses that they had no rights, in which case I guess the case would be over except for our damages, and I don't have to go after a party like Sphere who claims they don't have any money. I may be able to go after, or I am able to go after a party like Griffin. But I can decide that at that point. But what if we lose and Sphere has rights? Well, then all of the damages, all of the issues relating to breach of contract are based on Griffin's conduct. So let's say we litigate that and I win, and the debtors win. Is that res judicata collateral estoppel against Griffin? I would say I shouldn't have to litigate that again. And this is the conundrum that we have. I can see it's a very complicated, complex issue, but I think the way to slice through it, have the defendants respond to the complaint. We'll deal with it in appropriate briefing, either a motion for stay, a motion to dismiss, whatever they file, and we can have an appropriate schedule based on that. What we shouldn't do is go down a path that would generate two different types of lawsuits about the very same operative nucleus of facts. They're virtually identical. The conundrum that we have is, what do we do about Griffin? And if we win, we don't want to have to litigate against them again. And that's really the driver at this point with, hopefully emergence around the corner. We're making reserves for these claims. We don't have to have them resolved before emergence. We just want to have it done once in front of you with all the facts and the parties in one place. And that really, at the end of the day, is what we're asking for, Your Honor. Vacating the schedule in the contested matter, consolidating it with the adversary proceeding, and then have the schedule for them to file whatever motions they're going to file.
So, Mr. Secretary, let me just ask you a couple of clarifying questions, at least clarifying for me. Yes, when everybody appeared in front of me in October, everybody was telling me how important keeping deadlines was. And the Sphere litigation was mentioned, but I don't remember hearing about Griffin and potentially this adversary proceeding coming up. So what type of timetable are you thinking may work? And two, what thoughts do you have about, I guess what's I'm sure Sphere is going to tell me is that now we're going to open them up to a whole nother round of discovery and a whole bunch of expenses when there was a scheduling order saying they were ready to go in January. So how do I? And you can take them up in any order. Yeah. I just want to know kind of what your thoughts are with respect to kind of preserving what's already happened in terms of scheduling, and assuming there was a schedule, kind of how quickly do you think all these issues could get teed up?
Sure. And look, all fair points, obviously, Your Honor. And I think, the debtors, like any litigant, and look, litigation's a contact sport. We weren't going to let everybody know what we were thinking, but clearly when things were coming together with the planned mediation discussions and we kind of started to see where things were going to go, candidly, without getting into details about obviously attorney-client discussion, we were thinking about, well, what about the claims that we have, and what about we have these contracts with Griffin, we need to do something. So we were thinking about it, but it would have been premature for anybody to stand up, and frankly, at that point, it wasn't a done deal what we were going to do to say anything about it. So I totally appreciate that there were schedules out there, and this motion is to vacate that schedule, but I think the way we were looking at it, putting aside for a moment Griffin's apparent desire to arbitrate, our thought was, look, this discovery does not go to waste. We both subpoenaed Griffin. They produced documents. Frankly, if anything else we did with Griffin would be maybe some interrogatories and requests for admission, but it's not like the documents we produced to Sphere and that Sphere produced to us get thrown away and we start over. Like, we have them in relativity, we can easily just produce them to Griffin. And I can't imagine with very, very small pieces of evidence on maybe the damages, maybe on some more Griffin issues, it's the same documents. It's not like the issues all of a sudden changed. They're the same issues. So I really don't buy the argument that we have to start over, because we don't. We both have the documents. We give them to Griffin. Griffin's already produced documents to both of us in response to subpoenas. So, frankly, I would say they should file. If they're due the 21st, if they need a short extension, that's fine. They should file whatever motions they want to file, and we'll brief them as we would any case. So the discovery is not lost. Yeah, I'm sure people prepared binders to take depositions, but that's not really prejudice, and we did too. But nobody took a deposition. And this is important. We think it was the right thing to do, to not go down the path of depositions first and then file the adversary proceeding, because that would have been a mess, because then Griffin would have had rights. So nothing's really lost. So one of my answers to your questions is nothing's lost. The discovery is there and can be provided to Griffin. And in terms of the schedule, I would treat it like any other adversary proceeding. They should file whatever motions they want to file, or frankly just file an answer and let's litigate. But then we could have this wrapped up, I'm sure, in 3 months. If putting aside the motion practice, I concede, will add some delay. But if we just had a straight up litigation at this point, we already have a head start with the documents that were produced. So I don't see it taking that long from ready to go, we're starting discovery, to a trial taking more than 3 months. I hope that answered all your questions.
No. It did. It did. I just wanted to try to get a feel for, whether you all were contemplating kind of a February, March, or a July, August trial date with respect to these matters. I just didn't have a good feel for timing and what.
Yeah,
would
I'm
be
thinking like
involved.
April, May. I'm sorry, Your Honor. April, May. I was thinking something like that.
Okay. Let me hear from Sphere.
Thank you, Your Honor. I neglected to mention that
Actually,
President.
Mr. Wolf, just one question. I'm looking at my notes here. I had one more question for Mr. Socrates, and then I'll turn to you, and I'm going to ask you all the same question. So December 18th happens. December 19th. Are we all smarter on December 19th, or do you think not? In other words, in terms of kind of where the state of play and kind of the way the pieces are going to get moved on the chessboard, are we all smarter on December 19th, or not?
Well, unless the parties, and I don't want to put the lawyers on the spot, but unless they're going to tell me like right now that they don't think the contracts are executory, then we will have solved, and they're not going to file proofs of claim for rejection damages, then we're not smarter in the sense that we know what they're going to do, but we have removed one more potential issue, which was Sphere's point that apparently we've been withholding minors that they asked for. So that would be mooted, and then the minors get picked up by whoever. We would say Griffin, and then Griffin can do whatever they want with the minors, and so then they'd at least be out. We'd have that done, Your Honor.
And assuming that goes away, then what's left to try with respect to Sphere?
Well, you're talking about just this contract rejection point?
Yeah.
Yeah. So if Griffin were to say today that they're executory contracts, they take the minors back, there's no rejection damages, then we would not have that issue of rejection damages in front of the court. We would still have like the meat of the fight,
right,
which is basically Sphere's proof of claim. But my guess is, and I'm not going to speak for the other parties, that they're not going to tell us that. They're going to say at a minimum that they're reserving their rights to bring rejection damages claims or fight us on whether they're executory. And then the same issues that are involved in fighting those damages claims are the issues that are involved in the Sphere proof of claim.
Got it. Thank you. Mr. Wolf.
Sure. Thank you, Your Honor. And I was remiss before not mentioning that also present in the courtroom is Ms. Trompeter, who is Sphere CEO. I'm also joined by my associate, Rahul Srinivas, who I think will be putting a demonstrative up as I speak, if that's okay, Your Honor.
I'm sorry, who do I turn it over to?
I'll be talking, but we'll be putting up a demonstrative while we talk.
Oh, that's what I'm saying. Who do I give the... Is it Sphere's presenter?
Rahul Srinivas, if you help.
Your Honor,
I got the video to work. Sorry.
Pardon me, this is Ashley Harper.
We could also hand up a printed copy, and I could just direct you as I go, if that would be easier.
Your Honor, I do have a printed copy as well, if you'd like me to hand it up. But on the screen, I think the person has named themselves Sphere Presenter.
Okay.
If that helps the court.
I see. Sorry.
Yep. I saw them a second ago. Let me find them again, and I will give them the power.
And, we may be doing this.
Oh, I see it. I see it.
Yeah.
Yep. Person put both names up. Like, you can find me either way. Hold on.
Always prepared. Would you
Thank
like a
Yeah, if you got a handcuff, that'd be great too.
Okay. And also, before I really get into the meat of things, as a housekeeping matter, I move all the exhibits on our exhibit list into evidence for purposes of this hearing and record only. And those are docket numbers 1482-1 through 30 in the main case, and docket numbers 20 through 24-1 through 30 in the adversary proceeding. And since we had this one time before, I'll give my friend on the other side the chance to do the same before I get into it.
Yeah, Your Honor, we really don't. We have a relevancy objection for the emergency motion. These documents really don't. I mean, there's some back and forth from our discovery disputes, which are not before the court, and then some documents from the case about the merits, which are not before the court. If the court wants to take them for purposes of consideration, we don't think they should be in evidence because they're not evidence relevant to these proceedings. But if the court, now it's not a jury issue, if the court feels that it has a benefit from looking at them, that's fine. But we don't think they should be in evidence.
Yeah, I agree. I'm not gonna admit them into evidence, and then we're going to prove them up anyway in the courtroom. So, but it's okay. I want to make sure that Mr. Socarides, it sounds like you're okay with me looking at them for purpose of consideration, but not into the record, and I think that serves the same purpose.
Correct. That's fine, Your Honor. Right.
Thank you.
All right. So, Your Honor, I'll just begin with Mr. Socarides, begin with a short background. I'll just begin with a short background in our view of the case, and then I'll jump to the motion. So our perspective is that over the course of a little over half a year, Sphere provided CORE with $35.1 million in deposit funds in contemplation of future hosting services. And CORE recognizes the deposit payments as deferred revenue, meaning CORE does not recognize those payments as actual revenue unless and until it delivers hosting services. CORE has provided, although we've provided $35.1 million in deposit funds, CORE has provided about a few $100,000, maybe $1 million worth of services. And before it made clear that it would no longer uphold its end of the bargain and host our minors. And it's undisputed that CORE has retained the bulk of the deposit funds. So we're talking $33 to $34 million without delivering those services, which remain sitting on their books as deferred revenue. And the other issue that's going to take paramount in the case is CORE also plugged in Sphere's miners as its own and used them to mine Bitcoin for its own benefit. We say wrongfully taking at least $500,000 for itself that should have gone towards Sphere. These are questions that should be addressed at a trial, and you'll be ultimately deciding whether CORE is entitled to a $34 million windfall at Sphere's expense. And as I'm sure your honor is now aware, it was in our briefing, and you have likely read the court transcript and the briefing on the motion for summary judgment. CORE actually moved for summary judgment on what it viewed as the dispositive issues in the case, namely whether there was this assignment and whether certain limitations of liability would have reduced Sphere's claims to the point that it really wouldn't have been worth it to prosecute the case. And the court denied that motion for summary judgment after complete briefing and a hearing on the merits. And so here we are. And turning to the motion, our position is that these are issues that should be addressed at trial in January 2024, which is exactly what CORE asked for. And you mentioned at the beginning the importance of meeting deadlines. And we have taken those deadlines seriously, and we don't think our adversary did for strategic reasons. I would start with slide 12. And given what was said to the court during the summary judgment and scheduling hearing, sorry, the next one, please. 12.
Your Honor, would it be possible for them to send us this deck so we can at least go through it and not have to rely on the flip?
Sure, we're happy to do that.
Yeah, why don't we do that? But Mr. Socarides, why don't I then step off for about 5 minutes, make sure that you've got it, and maybe you can, counsel can also send it to Ms. Hardy, that she's got it. She can, so just so she's got the ability. It sounds like she's got a hard copy here as well. Why don't I come back on in 5 minutes, and then just want to make sure that everyone who needs to get a copy of it can get it, and we can go through it.
Sure, and I'll send it to Dennis as well.
Alrighty. Thank you. I'll come back on in 5 minutes. Okay, we are back on the record. Mr. Sacarides, just want to make sure you got the deck.
We have the deck. We've had a chance to quickly peruse it.
Okay. Alrighty. Let's proceed. Mr. Wolf.
Thank you, Your Honor. So we start with slide 12. Given what was said to the court during the summary judgment hearing before Your Honor took over, and given the course of the proceedings, we were very surprised to receive the unilateral notice from course counsel last week. The depositions that should have begun this week, 2 days ago, and the trial that's scheduled to begin in 2 months would no longer proceed. And if we could jump to slide 14, what we were also surprised by was that some of the things that we read in my adversary's motion did not account for their prior positions before this court, again, before Your Honor took over this case, in which my friend on the other side really glossed over in his presentation. During the August 7th hearing, my adversaries informed the court the trial should be completed, Your Honor, this month, by December, but it just had to be, and I mean had to be, completed by January, with all the expedition and expense that entails, and that we have already borne. And my adversaries were clear that a trial in April 2024 was a non-starter. Now we're in limbo, Your Honor. Maybe we have a trial in March. Maybe we have a trial in July. Who knows? And this is a real problem for us. And it's not even clear that Griffin would be ready to have a trial in April or May or July. And it's unlikely they're even going to be a part of the case, given that their case is likely to be sent to arbitration, or at least will be subject to pending appeals. It's an issue from our planning purposes, and it's also an issue for our CEO, Ms. Trumpeter, who has been scheduling her treatments around the trial date. She had originally her next treatment scheduled for April. Now, with the pendency of this motion, she's looking to see if she can get that pushed back to January. It's not clear that she will be able to. She's on a waiting list. Next, if we could go to the next slide. During the hearing, the court asked if my adversaries would be pursuing any other actions, including for damages against Griffin or Spear. And I'm going to quote what the court said before you took over. You're objecting to the proof of claim. And so if you win, you're not pursuing anything else. You're just done with that. Is that right? And my adversary's response was that they would not be pursuing another action that would mess up the schedule. Yeah. My adversary continued, and so if we won, at the end of the day, all of that would be it. We wouldn't be pursuing anybody else for money because we'd be resolving that issue here in this context. That statement is ignored in my friend's brief, and it's ignored in my friend's presentation. And if we could go to the next slide. Again, during the hearing, before you took over, the court explicitly asked whether it made sense to join Griffin to the proceeding because it was worried that adding Griffin later might result in the exact situation you're in, that it would just mess up the case schedule. My adversaries explicitly said they did not want to add Griffin to the proceedings. Now we're hearing a whole lot of mumbo-jumbo about how they're terrified that they're going to have inconsistent results if the contracts are declared to be executory or not. Release that it's speculative that either party, Griffin or Spear, is going to seek. And during the course of the proceedings, to account for Ms. Trumper's health, we explicitly asked if trial could be moved by 2 weeks to the week of January 17th. My adversaries initially refused and only relented when we made clear the severity of Ms. Trumper's situation. But Your Honor, the situation was never about moving the trial date a matter of months. It was always about an adjustment of a few weeks, given what they had said about the urgency of completing this. And there is no reasonable explanation for the delay in filing. I haven't heard it. You haven't heard it. In their opening brief, they did not try to offer any sort of reasonable explanation. Instead, they offered an explanation that I've never heard, and I don't think any court has ever said would be good cause, that they wanted to try and settle the contested matter and apparently planned to possibly file an adversary proceeding if they couldn't secure a settlement. And, Your Honor, the reasonable conclusion is they never took the expedited case schedule seriously. And the reasonable conclusion is that CORE was trying to exhaust Spear's resources, which, because Spear is publicly traded, CORE has known to be limited. Your Honor, they have our $35 million. Those are $35 million we desperately need. And, Your Honor, this is about as bad as it gets. CORE used the case schedule as a weapon to try and extract a settlement from us. Now, having gotten the expedited schedule it wanted, CORE does not get to rewrite the case schedule because, keep in mind, Your Honor, CORE is willing to settle, but just for a bit more than CORE has offered. And in fact, CORE has just never given a resolution a serious chance. It has refused several invitations to mediate before Judge Isger. We offered to mediate on August 11, 2023. CORE said no. CORE did not even make a counteroffer to us until late October, which belies the notion that they were just trying to settle this and would have filed the adversary proceeding earlier if only they had been able to settle this action. Ms. Trumpeter proposed mediation on October 26th. CORE said no. And although the parties were not that far apart, we again proposed mediation on November 6th. CORE said no. And we finally proposed mediation on November 17th. And instead of mediating, CORE reacted by filing the adversary proceeding. Your Honor, this is not the conduct of a party who's looking to find a reasonable settlement. A mediation does not necessarily only push them up. It may push Spear down. That's why parties mediate. And after we made clear in our brief that the settlement point was nonsensical, they've shifted tacks and are arguing it was simply the cadence of the case. My friend on the other side has said, we were thinking about this in October, but I can't reveal anything because of attorney-client privilege. This is just a post hoc explanation, Your Honor. This court explicitly invited this proceeding in August, and my adversary knew the efficient thing to do would have been to file it immediately. They're seeking a break on the case. They, in fact, opposed moving the case schedule on October 25th. At the same time, they were telling Your Honor that they take scheduling seriously and that apparently they were considering this adversary proceeding very seriously. Now, setting aside motive, which we think is highly relevant, let's put up slide 18, please. The fact remains that the adversary proceeding and contested matter are in very different places. And the case law is clear that that on its own is ground to maintain the present schedule and retract the motion. As Your Honor knows, the case is on the eve of depositions. They were supposed to begin on Wednesday, and the trial is less than 2 months away. The adversary's proceeding is just getting off the ground. My adversary makes it sound like discovery will be minimal. Perhaps if it were just Spear and Spear and CORE litigating against each other, that might be so. We will need to serve additional discovery on their new damages claims, but as my adversary said, that will not be the most burdensome thing. However, the presence of Griffin makes this different. Griffin will need to serve interrogatories. It will need to respond to interrogatories. It will need to serve RFAs. It will need to respond to RFAs. Griffin responded to a subpoena and made document productions pursuant to a subpoena. Its obligations were accordingly much smaller than it would have been if it were a party. Griffin has not disclosed its search parameters to us. It has not filed a privilege law. These are things it will have to do. There would be, and my adversaries, they can say, well, we'll just accept Griffin's production. I don't know that we would, Your Honor. There's likely to be cross-motion discovery. So all that's a way of saying is there will be a substantial delay. And if there is significant delay, Spear will suffer prejudice. We are deposition and trial ready And as our adversaries know, because we're publicly traded, short on resources, we need the contested matter to go forward, and we need to know whether the claim will be allowed or disallowed. And because the schedule was expedited, we incurred additional expense and had to front-load those expenses on the expectation that we would just have an expeditious trial. And we made business decisions to prioritize this litigation over other revenue-generating activity. Court asked for an expeditious schedule, and it's fair we stick to it. And at bottom, Your Honor, granting their custody leave would reward gamemanship. We've been preparing for depositions and trial, preparation that is going to go out the window due to the passage of time. Meanwhile, court will have achieved its apparent goal of delaying depositions while we incur additional costs. And, Your Honor, I think discovery has gone well for us. I don't need to go into the merits on that because all you need to know is that court proposed dropping motions for summary judgment. That's not something defendants do if discovery is going well for them. And court cannot seriously believe in this adversary proceeding, which currently seeks $100 million in damages. Parties don't sit on those types of claims if they think they are worth something. Of course, it would be relevant to all the creditors to have known that court had these apparently great $100 million claims that are going to be collectible. That's very relevant to the state, especially when court is saying it does not have any money to pay out its creditors and instead must pay them out through equity. And there's certainly no reason for them to have delayed asserting the claims against Griffin, given that they believe that that's who they are in privity with, and a settlement with Spear would not have resolved their claims against Griffin. And finally, Your Honor, I just want to address this argument about efficiency. The efficient thing to do would have been to support the adversary proceeding at the outset when the court invited it. And because Griffin intends to move for arbitration, there will be no efficiency gain. If Griffin prevails on its motion, the case will be sent to the arbitral forum. Accordingly, there will be one case against Spear in this court and one against Griffin in the arbitral forum. And if it loses, Griffin will have the option of seeking 3 levels of appellate review: district, Fifth Circuit, and Supreme Court. The proceedings will be automatically stayed during that time. The case against Griffin could drag out for years. I'm not sure of the exact, the Supreme Court's decision in the Coinbase Bielski case is very recent. I'm not sure if that will also mandate a stay against, as between Spear and court as well, if the case is consolidated. So win or lose the motion for arbitration, there will simply be no efficiency gain. Now, to maximize efficiency, what we've proposed is that the court defer consideration of the adversary proceeding and any offset issues until after trial. And instead, at trial, deal with the allowance issue and the amount of the allowance. Maybe this prompts the parties to finally do what they should have done at the very beginning, which is mediate. But no matter what, it will focus and streamline depositions and trial. It'll reduce the matters in dispute. And if we have to have a second proceeding down the road, so be it. We're prepared for it, Your Honor. And in sum, I urge you to reject court's request of relief.
Thank you. Mr. Secretary, I'll give you an opportunity to respond.
Do you want me to do that now, or do you want Mr. Tracy to, since he's sort of half with me and half with them?
Oh, I apologize. Mr. Tracy, I'm sorry. Now I can see all the cameras again. I apologize.
Mr.
Tracy, you may be on mute. I don't know if I've unmuted your line. If you can, just hit 5-star. Oh, there you are.
Your Honor, I think my line is now unmuted. Can you hear me?
I can hear you just fine.
Great, thank you. I apologize for technical difficulties at the outset and wasn't able to make our appearance. I'm Dennis Tracy from Hogan Lovells with my colleague Richard Wynn, and we represent Griffin Digital Mining. Thank you for having us.
Don't worry. Please, anything you wish to say.
I'll be brief, Your Honor. As you know, Griffin entered into the MSA agreement with CORE. We specifically negotiated to assign that agreement to Sphere. That was the whole purpose of it. We then entered into the sublicense and delegation agreement, and pursuant to that, Sphere deposited the $35 million. And so we are leaving it to Sphere to litigate that issue. And we've recently been brought into the case. First thing we did, of course, was to ask for mediation of both parties. That request was not responded to, and shortly thereafter, the adversary proceeding was filed. As we informed the court, the MSA, which is the contract under which the adversary proceeding was brought, has a very broad arbitration clause, which requires that any dispute relating to the MSA must be brought in arbitration in Seattle. And the parties having agreed to that, we intend to move to compel arbitration. And that said, we have no objection to the continuation of the claim by Sphere and the resolution of that by the court. But any claim by CORE for damage against Griffin must be resolved in arbitration. And I would say the last thing is with respect to the executory contract, we have not taken any position on that and aren't prepared yet to do that. Most of those discussions have been between the parties, but at the request of the debtors, we can certainly jump into those conversations and do it through counsel going forward.
Thank you. Mr. Sekerides.
Yes, thank you, Your Honor. First, let me start with, we didn't want to get too into this, but we do object to the serious accusations and the gamesmanship. I mean, this is, as Your Honor knows, Chapter 11 do have a cadence. And in August, it didn't make sense to do it. It made sense to do things in November. So I'm sure the court knows how things operate. There was no bad faith intent. This was a litigation, and we had different set and bigger fish to fry in August than we do now. But I think the bigger issue is, what do we do now? And I just heard Mr. Tracy say he wants to have Sphere's issues decided by Your Honor. Well, if Sphere's issues say that Griffin breached the contract, then he's bound by that. So we have to figure out a way. I'm not going to litigate against Sphere and win. Let's say this is the first I've heard that the purpose of the MSA was to assign it, that the facts will not bear that out. But even if Sphere has rights, we then have defenses that they were breaches, and the breaches were by Griffin's conduct. So if we prevail at a trial and summary judgment motions get denied not on the merits, it's because there are fact issues in dispute. That's why we didn't think we should have a summary judgment motion, because there are fact issues in dispute. But if we have a trial with Sphere and we win that there was a breach of that contract, I don't want to hear from Griffin that they weren't there or that they're not bound by that. That's our concern, because that's what's at issue on the Sphere POC. It's not just that they're entitled to money back. We think they forfeited that money. We don't think they're entitled to that money. And we think we have claims and defenses with respect to that. So if we win, what's Griffin going to do? I haven't heard anything about that. That's our concern.
Understood. So let me just note, November 25th, there was a emergency motion to vacate the scheduling order in the Sphere contested matter and to consolidate the Sphere contested matter with the adversary proceeding that was filed on November 21st. I'm going to find certainly a core proceeding today, and I have jurisdiction to resolve the issue. The court has considered the arguments of counsel. There have been a number of documents that have been not admitted into the record, but have been used, quite frankly, what I'll call as demonstratives to kind of, so the court can take notice of the record as to kind of where we are. Note, there is currently a scheduling order in place. I that contemplates a trial in the Sphere matter, as a contested matter in January. Based upon what I've heard, I'm going to make a couple of. I'm going to rule on the issue, and then I'm going to make a couple of observations. I'm going to deny the emergency motion. We're going to stay on the schedule that we are. It's been currently scheduled that way. I reject. I don't find any bad faith by bringing the motion. I think cases are complicated. Cases always have moving pieces. People don't always have to tell judges what they want to do and when they choose to do them. And I think certainly the debtors had every right to bring the motion to seek to vacate. And there really is an efficiency argument here. And there's also kind of a practical ramifications as to what happens, because they could have legal consequences for parties who aren't involved. And so I think there was a good faith basis to bring it. I just think we're so far along into the scheduling as to where things are, where a trial was scheduled to begin, quite frankly, originally in about 30 days. And now it looks like it's just going to go to the end of January. I think the schedule should continue along that path. There's a lot of unopened doors. I think we need to remain unopened now in terms of what a scheduling would look like if taking a briefing on arbitration, potential motion practice. This could easily slip into the middle of the year, and I want to make sure that this case stays on the tight timeline. I reserve the right, however, to revisit if it starts to look like things make a lot more sense later down the road. I think we'll all be a little smarter in January. I reserve the right, but I will say this, and I'm only saying it because it's said. I intend to take the trial up. I intend to try to rule on this if I can, right there at the hearing. If not, I'm going to make very detailed factual findings, and the legal effect of those findings will have whatever they are. So I really want the parties to really focus on making a robust evidentiary record, because I'm certainly going to be expecting it if we have the trial in January, and the legal effect of what those are will be what they are. I think with respect to the, I don't want to comment on motions that I haven't seen, so I will reserve all rights with respect to Griffin and the arguments that could be made with respect to arbitration. I appreciate the heads up that it's coming, and I think it would be, I ought to reserve everything until I read something on those points. So I think we stay on the schedule that we're on. But if it starts to become highly impractical, I reserve the right to kind of come back and revisit where we are. But I think the depositions that are scheduled should go forward, and let's just stay on the schedule, and we'll see where we go.
Yeah, Your Honor, on that point, we never had a. So we have a schedule that has a trial date. It got moved in the interim, and we don't have an actual revised order. So I think we'll either have to talk among ourselves, because there is no actual schedule right now. So and I'm not suggesting I hear what you're saying.
No, I know what you mean. You want to lock some dates in so that I got it. I got it. I think that makes a lot of sense. I was going to end by saying I hope the parties can kind of work together and try to figure something out. If not, then Monday we need to all get back and I'll make the call if we have to.
Right, because either, and I'm just talking out loud here at the risk of doing that, either we're going to leave the trial dates in with the 30th through the 2nd, whatever it was, and then work back from there to get the depositions done between now and some reasonable time in advance of that. Or, and again, like, I don't want anybody freaking out that, maybe we need to move that a week or two to make up for the depositions. But we don't have to decide that today, but hopefully counsel.
I think that's right. I think that's right. I think that's exactly right, because we've got to look at schedules and we got to make sure that it makes sense in light of kind of where we are. So I don't want anyone to, if y'all get together and figure it out, I will make the time. I will lock it out. I won't be the holdup in terms of my scheduling on that. So let's just figure out what makes sense. I want to lock things in by no later than Monday, And if there's an order, I won't get in the way of it. But if we need to, and I will just tell parties for the contested matter, unless there's a kind of a real reason why someone can't appear in person, I just think all the witnesses and anyone who's going to examine the witnesses, I want you here live. Primarily, the technical issues sometimes come in, and I just want to avoid all of that to the extent possible.
Your Honor, we will meet and confer with our adversaries promptly and over the weekend if need be. And if it is the case that in planning it, we need to add 2 weeks, I'll need to talk to my witnesses and make sure everyone's available. But we were planning on everyone being in the courtroom.
Okay. No, I'm just throwing it out just so it's really clear, kind of the way I think this should play out. So I would ask if someone can just, quite frankly, if the parties, Mr. Wolf and Mr. Zacharides, if someone, you can email my case manager on Monday, let me know if we need to schedule some time to kind of hammer out some dates. If you need time of the court to do it, just Monday morning, just email her or email her on Sunday or Monday and let her know. And we'll figure out a time on Monday if we need to kind of get together in the afternoon to talk. If not, I'll let the parties work through the issues, but it's just a kind of a heads up.
Okay, that's great. We might have a few by deposition, so we'll see. We'll set that up. You know, they obviously won't be live, but they'd be non-parties.
Okay. All right, folks. Thank you very much. Have a good day. Oh, hold on a second. Ms. Hardy wanted to tell me something.
Your Honor, Jennifer Hardy of Volke Farm on behalf of the official Unsecured Creditors Committee. I just wanted to give the court a heads up. As you heard at the disclosure statement hearing, the committee still has an ongoing objection to the plan, and we served discovery promptly after the disclosure statement hearing. We have one party that we still have a remaining discovery dispute with. We do expect to have to file a motion to compel in front of Your Honor, perhaps as early as today, and we'll reach out to Ms. Saldana to get a hearing date on that on an emergency basis. We would likely ask for something early next week because the confirmation hearing is 3 weeks from today.
Okay. And just depending on the time on that one, I will, depending on when you file and depending on when I set it, to the extent someone needs to appear by video on that one, I'm fine with that because it'll be done on an emergency basis. I don't want someone, but I got it. I appreciate the heads up.
Thank you, Your Honor.
Thank you.
Appreciate it.
All right. Thank you very much. I'm going to just give everyone, I'm going to step off for 2 minutes and then I will come back on with the 10 o'clock. Thank you.